So today, I'd like to share some thoughts with you regarding the standard setting organizations, SSOs, their contracting practices, and the appropriate role of antitrust in regulating those contracts, if any. In particular, I'm going to focus on licensing issues involving standard essential patents, SEPs, that arise from intellectual property right policies. Terms of art from the economics of contracting, hold up, reverse hold up, ex post opportunism, are commonly invoked around current debates involving SEP licensing. Indeed, some of these terms appear to have taken on a life of their own when applied to SSO contracting specifically. While I also approach patent licensing issues from an economic perspective, I'm concerned that some of the important economic insights regarding incomplete contracts in particular have been misunderstood, misapplied, or ignored altogether. Economists have long recognized that the very literature upon which the current patent holdup agenda is based teaches that private ordering and contracting play an important role in governing ex post opportunism. Indeed, the economics of holdup began not as an effort to explain contract failure, but rather as an effort to explain real-world contract terms, performance, and enforcement decisions, beginning with the fundamental premise that contracts are necessarily incomplete. The incompleteness of contracts did not signal inefficiency in its own, but rather incomplete contracts were a predictable and efficient result given the cost associated with identifying all of the contingencies that might arise during the life of a contractual agreement. Understanding the contracting process and the role of incompleteness and ambiguity in contracts generally, and here in SSO contracts, is a necessary first step toward understanding what incentives different legal and regulatory regimes will have upon that process. It is impossible and likely counterproductive to talk about the relative efficiency of one set of rules governing these contracts or another without first understanding the underlying contracting process itself. Only with that understanding in hand can one begin to analyze the desirability of different legal frameworks to govern the possibility of ex post opportunism or holdup with respect to SEPs in the SSO context. Much of the current debate surrounding SSO contracts involving SAPs is based upon precisely these sorts of questions. For example, is the availability of injunctive relief as opposed to monetary damages for infringement desirable in the shadow of a FRAND commitment? Or what will be the effect on SSO participation and innovation of imposing antitrust remedies for what amounts to breach of such a FRAND commitment? Many policymakers and academics have developed fairly strong priors that SSO contracts are inherently inefficient due to their incompleteness. In particular, the ambiguity of the FRAND commitment and the lack of precision concerning when injunctive relief may be permitted. Based on those priors, certain policymakers and academics often argue the SSO contracting process is broken and requires additional legal protection to afford potential licensees and consumers greater protection. I want to challenge some of those priors today. I do not believe that conclusion, or many of the policy measures suggested or already adopted, follow from the relevant economic principles, or where economic theory offers conflicting predictions, follows from the available empirical evidence. SSOs have long played a crucial role in our innovation-driven economy, and this fundamental role has only intensified over the past few decades. SSOs develop, support, and set interoperability and performance standards, among others, which help to facilitate the adoption of new technologies. By the early 2000s, hundreds of collaborative SSOs existed worldwide. They're comprised of firms, large and small and anywhere in between, and include members that contribute as well as members who adopt and implement technology. SSOs also span a variety of industries and technical categories, including aeronautics, life sciences, telecom, electronics, and others. Standards, as it's well understood, can make products more valuable for consumers and less costly for firms to produce. Interoperability standards, for example, ensure that products manufactured by different companies are compatible with one another. It can also reduce companies' cost of production by making it less costly for them to acquire technical information and simplify product design. For consumers, standards facilitate interoperability from a wide adoption of the standards, which in turn can help protect consumers from stranding and result in a greater realization of network effects. It's important to recognize that SSOs are not the same contractual institution as a patent pool, despite confusion among many commentators and sometimes even judges on this score. Each institution represents a distinct private ordering response to a different problem. A patent pool, on the one hand, is a response to a failure precipitated largely by the law. High transactions cost in terms of both coordinating extensive numbers of patent owners and hold-up costs resulting from many patent owners having overlapping legal property rights over the same product. An SSO, on the other hand, is a response to a failure precipitated by technology. High transactions costs that result from lack of a standardized platform for production and use of technological products. Because they arise to solve different problems, it's unsurprising that SSO contract terms are negotiated in a very different legal and commercial context from that of patent pools. When developing and setting standards, SSOs typically require their members to disclose their intellectual property rights they own and ask for a commitment, and often ask for a commitment, to a FRAND royalty rate for a license to any IPRs the members contribute that become standard essential. Working groups within the SSOs then review and evaluate the various contributed technologies, and through many discussions among engineers and technical experts, determine the best technology or sets of technologies for the standard. IPRs deemed essential by the working groups are known as SEPs. SSOs member firms compete vigorously for inclusion into the standard during the evaluation process, in part because owners of SEPs are guaranteed a steady revenue stream from licensing their intellectual property rights. That said, SSOs are obviously not the only way by which standards are set. Standards can also be set through competition in the marketplace, whereby firms compete vigorously in a standards war, and the market eventually tips towards one or the other. One classic example is the competition between VHS and Beta before the market ultimately tipped toward VHS in the 80s. Either way, firms compete against one another for their technologies to become the standard. The difference is not whether competition takes place, but where and on what terms. Of course, the standards that would emerge through one of these mechanisms versus another, because they involve different types of competition, may well have different implications for efficiency and consumer welfare. Most recognize that an initial industry-wide standard can have significant benefits, including a higher success rate of launching a new network and introducing important technologies to the marketplace, greater realization of network effects, increasing protection afforded buyers from being stranded from the adopted technology, and enabling competition within an open standard. An SSO set standard also avoids the standards war, where firms have to incur significant costs in order to establish an installed base of users. Consumers may also delay purchasing until the de facto standard is established. Nevertheless, some have asserted that standards achieved collaboratively, that is, through an SSO, can impose cost upon consumers by reducing ex-ante competition and consumer choice, and by promoting proprietary control over a closed standard. In particular, many have emphasized the potential for patent holdup involving SEPs as a built-in cost of the SSO process, leading to higher royalties to licensees that are in turn passed on to consumers in the form of higher prices. It's well understood that the FRAND commitment may play a role in minimizing the risk of patent holdup. What's less clear is the exact meaning of that FRAND commitment, or for that matter, how one should go about ascertaining that meaning. Also unanswered, and an important question to me in my day-to-day work at the Commission, is the question of what role antitrust can and should play in regulating or responding to the effects of SSO contracts. Many competition enforcement agency officials around the world have asserted that SSO policies are either not strong enough or not clear enough, and in either case, raise the possibility that a regulatory response may be warranted to cure the inefficiencies resulting from the SSO contracting process. Some of these officials have offered free advice, quite generously, I might add, in the form of proposing specific improvements to SSO contracts. Others point to the role of antitrust law in deterring patent holdup and facilitating efficient SSO contracting to solve the SEP licensing problem. All of the discussion of proposed regulatory responses and even the free advice is based upon the presumption that there is market failure arising in the market that generates SSO contracts. I'd like to explore that idea further. The threat of holdup itself is a generally well understood economic phenomenon. In the SSO setting, after a standard is adopted and switching to an alternative standard would require additional investment, the holder of an IPR that is part of the standard can exploit its position by, to extract higher royalties when FRAND terms are vague. Generally speaking, the alleged imperfections observed in SSO contracts involve contractual completeness and what I'll refer to as the technical economic sense. That is, contracts omit terms governing some contingent possible states of the world that may arise over the future life of the agreement. Other alleged imperfections involve contractual ambiguity, such as the adoption of flexible terms that are subject to ex post interpretation. Consider the intentionally vague FRAND commitment common in many SSO IPR policies. The level of precision in those contracts with respect to the FRAND term is a selection made by sophisticated parties informed by a number of trade-offs. Most importantly, there's considerable uncertainty concerning the ultimate value of the technology, if adopted, and especially in dynamic and ever-changing markets. Contractual flexibility, ex post, can be an important source of economic value. Indeed, the entire economic literature surrounding patent holdup is based upon that very idea. There are additional reasons parties may favor less precision. For example, fear of antitrust liability imposes some costs of additional precision, as specificity with respect to prices, marketing, and distribution terms may attract the attention of competition agencies. Additional precision in the form of well-defined licensing commitments could also raise the cost of SSO participation. It's important to recognize that contractual incompleteness in this technical economic sense alone is not a reason to conclude that individual contracts are inefficient, much less indicative of market failure in the SSO process. Neither is the mere empirical observation of contracts that trade the cost of additional precision, the costly rigidity that necessarily arises from more precise language, for greater ex post flexibility. That observation is not a particularly unique phenomenon in the modern economics of contracting. That modern economic approach to analyzing contracts, in fact, typically begins with the observation that all contracts are incomplete, because the cost of identifying, specifying, and negotiating all possible future contingencies leads to that incompleteness, and only then does the economics literature proceed to discuss and analyze the incentives of contracting parties in light of different possible legal regimes. Unfortunately, most of the policy discussion, at least much of it, regarding SSO contracting appears to approach SSOs differently, presuming that contractual incompleteness in SSO contracts is sufficient to demonstrate inefficiency that might require further regulatory response. This logic requires one to naively assume that the relevant benchmark against which SSO contracts should be measured is a contract that's perfectly complete in the economic sense. This is a problematic presumption because, as any economist in the room will know, perfectly complete contracts in the economic sense appear only to be observed in economics graduate school textbooks and the occasional blackboard. The fact that a patent holder or licensee may ex post be able to take advantage of contractual incompleteness by engaging in a holdup of its transacting partner does not imply that the contract is inefficient when analyzed ex ante, or that it emerged from a defective contracting process. FRAND terms as written may well reduce the probability of future holdup without excluding the possibility altogether, that is, driving the probability to zero. Conclusions about the efficiency of such a choice require an analysis of the cost and benefits of further specificity in a contract relative to the status quo and relative to other feasible contractual arrangements. Some commentators firmly believe that requiring IPR holders to commit to more specific licensing terms before a technology is selected to become part of a standard would further minimize the risk of holdup. To be clear, Although neither the FTC nor the DOJ have to date advocated requiring SSOs to adopt any specific disclosure or licensing policies, former and current officials from each have suggested specific reforms, including stronger and more precise FRAND commitments that specify both the base to which a royalty should apply, the processes parties must adhere to in resolving FRAND rate disputes. The proposed reforms also include the recommendation that SSOs specify which licensing and cross-licensing arrangements involving SEPs are permissible and which will be prohibited. The approach of quote-unquote solving contractual incompleteness by recommending or perhaps even requiring certain contract terms would make sense if there was some reliable indication that the incompleteness observed in SSO contracts was indeed efficient. As I've already observed, however, neither economic theory nor available empirical evidence supports such a general presumption that these contracts are inefficient relative to feasible market alternatives. To the contrary, the potential efficiency of incomplete contracts is well understood in the economics literature. To perfectly prevent opportunism, much costly effort would be required to anticipate all possible contingencies and to negotiate and draft responsive terms. Indeed, in some cases, drafting enforceable terms perfectly covering all possible aspects of contractual performance is likely impossible. Transactors' reputational capital can also efficiently reduce the need for court-enforced terms. The efficiency rationale for incomplete contracts generally identifies a fairly intuitive trade-off between more complete contractual specification, which may generate benefits in the form of reducing the expected value of holdup, and the additional cost of precision, both in terms of negotiating and the rigidity of court enforcement. These costs are likely to be substantial in the SSO context. For example, additional negotiations could also slow down the standard setting process, further causing inefficiencies and delay in terms of bringing the technology to market, the commercialization of intellectual property rights, and rewarding inventors to continue to stimulate innovation. Of course, the inherent uncertainty in anticipating future contingencies over the life of an SSO contract, most important among them being changes in technology and its commercialization over time, renders SSO contracts necessarily imperfect in the economic sense and incomplete. One implication of this observation is that attempts to increase specificity may not bear fruit. The probability of holdup will never be reduced to zero. This point highlights why focusing upon incompleteness in individual terms rather than the contracting process itself is a troublesome approach and, in my view, a bit of a distraction from the relevant policy issues. The relevant question is not whether one can point to some contractual incompleteness, but whether there is reason to believe, based upon economic theory and evidence, alternative contracts would improve efficiency as compared to those observed in the real world. Another useful way to ask this question, to which I'll now turn, is whether there is reason to believe that IPR holders and SSOs systematically err in making the trade-offs already discussed. As I've pointed out, the key question is whether these contract terms are inefficient compared to plausible alternatives. The relevant comparison here, it's important for this comparison to again denote the distinction between SSOs and patent pools. The relevant comparison is between alternative institutional arrangements in defining and commercializing standardized technology, not in addressing the possibility of market distortions caused by overlapping claims of different patent owners to the same innovation. To identify whether SSO's incomplete contracts represent a market failure in need of fixing, it should be clear that we need an understanding of the competitive process. A starting point for that analysis is the contracts themselves, not often discussed in much of the policy literature. The SSO contracts themselves exhibit rich variation, which would suggest the terms respond to competitive forces at work and the specific needs of each SSO to design, incorporate, and attract IPRs that yield the best standard for their organization. Although some SSOs have no policies at all, others are quite well developed. For SSOs with IPR policies, the requirements imposed by those policies vary significantly. There's also rich variation in SSO rules governing the scope of disclosure, licensing arrangements, and whether members' ownership of IPRs within a standard is prohibited. Some require royalty-free licensing before incorporating the IP into a standard. Others require reasonable and non-discriminatory licensing. Some compel members to license worldwide to everyone using the standard, not just other members of the SSO. Certain SSOs provide guidance on the meaning of reasonable and specify a mechanism for dispute resolution. Others don't. The FRAND commitment can also take a variety of forms. It may be implicit from the patentee's participation in the SSO process, or by written acknowledgement of such obligation by the SSO. The SSO may require uniform FRAND assurances, or allow the IP holder the freedom to express its willingness to license on its own terms and by its own language. For example, the IEEE considers letters of insurance from 4 different owners of SCPs for the Wi-Fi standard. One promises the technology will, quote, be made available at nominal cost to all who seek to use it for compliance with an incorporated standard. Another agrees to, quote, to license on a, quote, non-discriminatory basis on unreasonable terms, including its then current royalty rates. A third provides no benchmark at all to roughly estimate the royalty rates it would charge. In short, SSO contract terms exhibit remarkable heterogeneity, quite consistent with the variation in market forces faced by their remarkably varied membership. Indeed, the significant variation we observe in SSO contracts themselves is precisely what one expects to see in a competitive contracting process in a diverse ecosystem of technologies and SSOs. The diversity in contract terms also reflects the many different ways SSOs seek to attract valuable technology contributors as well as adopters to their standards. Although some technology companies join more than one SSO, complying with differing disclosure rules and other policies across SSOs can be costly, especially for those with large patent portfolios. Economists Josh Lerner and Jean Tirole have examined a competition among SSOs to better understand how IPR contract terms are used to attract technology contributors and demonstrate quite convincingly that form-shopping technology contributors respond to sponsor-friendly contract terms. Competition to attract contributors, of course, does not imply that SSOs would always craft IPR policies that favor contributing members, possibly leading to higher probability of holdup. SSOs are also constrained to have policies that are attractive to adopter members. As all else equal, an SSO is more attractive to contributors with a larger base of adopters. SSOs thus have the features of what economists describe as a two-sided market, where they serve as platforms to join together contributors and adopters. As a platform, a successful SSO needs to attract members on both sides of the platform by striking a balance for the two sides with respect to their rules and policies. Again, the relevant question is not whether SSOs, contributors, and adopters face trade-offs in terms of balancing IPR policy, completeness, and precision. They certainly do. But whether there is reason to believe that sophisticated parties get the balance systematically wrong in a way that can be identified and improved upon by a regulatory body. SSO members elected to enter into incomplete contracts, presumably because they believe the contracts, though imperfect, struck the optimal balance between the cost of more precise terms and the probability and cost associated with holdup. Economists have long recognized that holdups occur when unanticipated events place a contractual relationship out of what we describe as the self-enforcing range, where transaction parties optimally combine court-enforced with self-enforcing sanctions like reputation loss. This probabilistic framework, where transacting parties enter contractual relationships despite knowing that holdup might occur, has important implications for understanding the structure of the contracts adopted by SSOs and their members. By entering into a contractual relationship with incomplete terms, the transaction parties reveal their belief that the expected gains from trade outweigh the expected cost associated with the possibility of holdup. This suggests that contractual incompleteness and ambiguity in SSO IPR policies is an intended and key design feature of SSOs. Indeed, despite the changes SSOs have made to many of their IPR policies and terms, the key ambiguities involving FRAND and other terms have largely persisted over time. The persistence of these terms in competitive markets over time suggests also, strongly in my view, that this imprecision is a feature and not a bug of the SSO contracting process. Thus far, as a simplifying assumption, I've largely ignored the role of reputation and self-enforcement in evaluating the potential efficiency of SSO contracts. But it's just a simplifying assumption. Despite the amount of attention patent holdup has drawn from policymakers and academics, there have been relatively few instances of litigated patent holdup among the thousands of standards adopted. This begs the question of why. If incomplete SSO contracts are inherently and systematically imperfect, as suggested by some, the empirical evidence on the frequency of holdup is so unremarkable. Reputational costs offer one possible example. That is, the decision to engage in holdup results in short-term gains that can easily be overwhelmed in a repeated setting. Indeed, most firms and IPR holdings are repeat players that hope both to license SEPs and to have their technology incorporated into subsequent standards. A reputation for engaging in holdup would make it much more difficult to convince SSO and their members to adopt a firm's technology in the future, which would reduce the firm's ability to earn licensing revenue. In addition, for firms that contribute patents to SSOs and implement standards and products, a reputation for holdup as a licensor could affect the firm's position when operating on the other side of the bargaining table as a licensee. So ultimately, is there a market failure in the SSO contracting process that requires, or even hints at, a regulatory response as opposed to private ordering solutions? The evidence-based approach to answering this question should rely on what we know in the theory and evidence. Basic economic theory tells us one possible market failure story involves the existence of externalities. In markets where externalities are present, economic agents do not sufficiently internalize the costs that their actions or particular rules they impose onto others. Does the SSO contracting process result in such externalities? Appears unlikely, as most, if not all, SSOs include both contributor and adopting members. And as I mentioned earlier, SSOs have incentives to strike a balance between the interest of both member groups and to increase the value of the organization as a platform. Some economists have suggested that licensees do not necessarily care about increased royalty rates, for example, because the increased rates are simply passed on to end users. This is also not likely to be the case. Bargaining over royalty rates in litigation involving licensee claims against SSOs to enforce contract terms suggests licensees do care. Further, licensees are not likely to pass on the full increased cost of a royalty rate increase. This makes complete economic sense. Very few end-use products, in particular those that incorporate standardized technology, faced a completely inelastic demand curve where manufacturers are able to completely pass on higher royalty rates to consumers. Additionally, I'm not aware of any reliable economic evidence that indicates royalty rates and final end-use prices are higher for standardized technologies. Others have argued SSOs are best conceived of as a collaboration among competitors who have entered into a de facto quid pro quo, which is one too many Latin words for it to be true, with antitrust authorities, by which the authorities allow collusive interaction in the form of standardization in exchange for tougher antitrust scrutiny. This argument strikes me as a rhetorical device that doesn't shed much light on the relevant economics of SSOs and their role in the modern economy. It's neither a serious claim that such a quid pro quo actually exists, nor is it an attempt to accurately describe the economic function of SSOs. And how could it be? There's no empirical evidence that supports the proposition that breach of an SSO contract, even one resulting in higher royalty rates, is somehow analogous to collusive interaction that we observe with naked price fixing. Further, courts have uniformly rejected this view when interpreting and applying the Sherman Act. In particular, to date, does not appear to be a single antitrust case that finds breach of an SSO agreement without evidence of deception in the standard setting process a violation of the Sherman Act. Antitrust allows, as it should, productive cooperation. As I discussed earlier, an initial industry-wide standard achieved through standard setting in SSO has potential efficiency benefits relative to the alternative, where standards are determined through a war in the marketplace. Moreover, although some may view SSO processes as collaborations among competitors, standardization as SSOs are subject to a rigorous evaluation process where contributing members compete to have their technology incorporated into the standard. That distinguishes it from the naked cartel situation offered in the analogy just discussed. The collaboration in these collaborations in SSOs are in fact a playground for much competition among competitors. This does not mean that antitrust cannot or should not play any role in the SSO process. Where antitrust laws can and should come into play, in my view, is when participants abuse and manipulate the standard setting process itself to exclude competitors from the market, such as in Allied Tube or American Society of Mechanical Engineers. The existing antitrust laws already deal with these possibilities quite well. There's no evidence that suggests SSO contracting processes are consistent with anti-competitive collusion, specifically, or with market failure in general. Instead, what we observe is a heterogeneous set of market participants in SSOs, apparently rigorous competition among the participants and their technologies during the standard setting process and among SSOs to attract sponsors, and a diverse set of contract terms that is reflexive and responsive to changes in market conditions. Would any of the proposed policy changes improve upon that outcome? Developing an understanding of the likely effects of these various proposals on SSO contract terms, and thus on efficiency and consumer welfare, depends upon and requires a robust understanding of the SSO contracting process itself. For example, how did the SSOs end up with the contract terms that we observe today? Was it an oversight, historical accident, coupled with path dependence? Were there particular reasons that necessitated the adoption of these terms? It's also necessary to understand the various costs of these proposals, intended and otherwise. Some of the proposed reforms are likely to have little effect on holdup, but may introduce new inefficiencies. For example, industry participants have noted they support policies that permit voluntary and unilateral ex-ante disclosure of specific licensing terms by a patent holder, but suggest that proposals for the federal government to promote a mandatory ex-ante IPR policy are likely to be costly and cumbersome with little benefit. Similarly, as discussed, an overly narrow focus on holdup alone is likely to overestimate its social costs. For example, economists have found that a legal regime allowing for damages for excessive licensing fees might well solve the patent holdup problem, but only at the cost of retarding innovation and SSO participation. Much of the call for SSO contract reform, whether under the guise of possible antitrust enforcement or just friendly advice on contract drafting, is based upon the notion that SSOs bear a special responsibility for constraining the market power of SEP holders. Indeed, the possibility of SSOs constraining the exercise of SEP holders' market power is purported to be the primary benefit of filling gaps in SSO contracts. However, it's unlikely SSO contract reform can bear the burden its proponents place upon it. SSO members are a heterogeneous group that includes, as discussed, contributing members as well as non-contributing adopters, with widely varying incentives. It's important to recognize SSOs are not necessarily always in a position to constrain licensing terms for SEPs at will. SSOs compete to attract key players to join and to contribute their technology to the standard, and can be, in some cases, at the mercy of certain members with essential technologies. However, even assuming arguendo, SSO contract terms can constrain market power newly created by adoption of the standard, that situation is clearly not always the case. For some SEPs, the relevant market power will be inherent in the underlying technology itself, rather than conferred upon it by participation in the SSO process. Imposing more restrictive terms can undermine key players' incentives to join SSOs and or contribute technology, which could have welfare-reducing consequences. Requiring stricter SSO terms might make it less attractive for IPR holders to join the SSO process. The social costs associated with deterring participation in SSOs may outweigh any potential benefits associated with further decreasing the probability of holdup. That could, in the short run, lead SSOs to more frequently select an inferior technology. Could also lead to a dichotomy between competing technologies, which would defeat the purpose of SSOs and deprive consumers of the well-understood benefits to standardization. Over the longer run, these reforms could undermine the desirable purpose of SSOs, which, among other things, facilitate compatibility and interoperability. To return to a key theme of my remarks today, yet another benefit of less precise contract terms is the flexibility they allow parties in quickly changing markets. For example, as many recognize, SSOs typically specify very little as to the meaning of fair or reasonable within the FRAND or RAND commitment. at least in part because there's significant heterogeneity among firms, technologies, and products within a given SSO. Other terms in IPR policies also must vary depending upon technologies and the characteristics of the members in a given SSO. One contract term of intense interest to many commentators lately involves whether injunctive relief will be available for FRAND-encumbered SEPs. In some SSOs, the availability of injunctive relief against infringers is very likely part of the underlying understanding among the SSO and its members. As such, the right to pursue an injunction in some circumstances was likely accounted for and incorporated into the patent owner's decision to join. Some commentators and some courts reason that, as a matter of contract, the FRAND commitment must be an agreement that communicates that damages are adequate compensation for infringement, and therefore an injunction should not be granted under the Supreme Court standard in eBay. No maxim of contract interpretation I'm familiar with requires this result. Indeed, it's difficult to imagine why such an interpretation would hold in general, in light of the fact that no SSO appears to uniformly disallow injunctions. To the contrary, some appear to expressly consider and reject such rules. Ex post interpretation of FRAND commitments to preclude injunctive relief can deprive parties of the benefit of their bargain, undercompensate patent holders relative to ex ante expectations, and reduce incentives to innovate and to participate in the SSO process. Further, it's well understood that weakening the availability of injunctive relief for infringement, including infringement of FRAND-encumbered SEPs, may increase the probability of reverse holdup and weaken any incentive implementers have to engage in good faith negotiations with patent holders. Some argue the primary purpose of injunctive relief is to allow patent holders to threaten to exclude a product from the market and thus enable extraction of royalties above the FRAND rate and other significant licensing concessions from willing licensees. Such reasoning assumes the rate negotiated with a threat has to be above the FRAND rate. That assumption, I think, is dubious. Although the rate negotiated with the injunction threat is likely to be greater than that negotiated without the threat of injunction, it does not follow that the former needs to be above FRAND. Moreover, a key role of property rights is and always has been to allow the property owner to exclude, which enables clear assignment of property rights and, importantly, facilitates economic exchange. That is, it's quite possible the reform's net effect would be to exacerbate the possibility of reverse holdup. That is, by stripping the SEP's holder's right to injunctive relief, a potential licensee can delay good faith negotiation of a FRAND license, and the patent holder can be forced to accept less than fair market value for the use of the patent. The threat of injunction can be a very important part of the bargaining process and is likely part of the benefit of the bargain conceived of by a contributing member of the SSO at the time it decided to participate in the standard. The existence of the threat does not necessarily lead to holdup, as some feared, but rather can encourage an infringing implementer to come to the negotiating table. Reforms that suggest undermining this bargaining outcome, or antitrust rules that would do so as a matter of law, create a significant risk of doing more harm than good based upon our existing knowledge of economic theory and empirical data. We can all agree that it's important to encourage SSO IPR policies that benefit competition and innovation, and that anti-competitive holdup in either direction can retard competition and innovation. However, it's another argument to say that economic theory or available empirical evidence supports the proposition that filling contractual gaps by suggesting specific terms with the threat of antitrust enforcement is likely to achieve those goals. In my view, that has not been established and is not likely to be established by rigorous evidence or theory. Indeed, there's at least as much support for the proposition that the proposed reforms and enforcement aimed at perfecting SSO contracts will do more harm than good for competition and consumers. This risk is underscored by the fact that mandatory or government-suggested contractual changes are not likely necessary given IPR policies themselves appear to adapt to changes in market conditions and events in a dynamic environment quite well. In my view, the antitrust laws are not particularly well suited to govern contract disputes between private parties in light of remedies available under contract or patent law. The same concerns extend to extend to attempts by antitrust agencies, attempts to influence SSO IPR policies. Caution should be exercised in both situations. Indeed, and as I noted in the beginning of the talk, economists have long viewed the holdup problem and ex post opportunism generally as a problem sounding in contract law with its default substantive rules and remedies rather than in antitrust law. The risk of imposing antitrust remedies in pure contract disputes can have harmful effects in terms of dampening incentives to participate in the contracting process and to commercialize innovation. These would be unfortunate consequences of policy forms and enforcement efforts designed to improve the competitive process. There are also avoidable consequences. The sanctions available to address patent holdup and related concerns under other legal regimes are more than adequate to provide optimal deterrence against patent holdup. Antitrust enforcement remains available in cases of true anti-competitive price fixing or deceptively manipulating standards. In the absence of robust empirical evidence to suggest that SSO's adaptation of their IPR policies over time have been inadequate in minimizing the probability of holdup relative to real counterfactual, feasible contractual alternatives, there's little reason to bring to bear the blunt weaponry of antitrust rules and remedies to micromanage the competitive process in the name of perfecting SSO contracts.